Okay, so good evening to everyone. Thank you to everyone that's here in person and all to everyone that's online. The title of tonight's seminar is Liberty, Privacy or Privacy, as the Americans would say, Abortion and the United States Supreme Court. Our guest is Professor Lisa Tucker from Drexel University School of Law. And before I present our speaker, let me just give you a little bit of background to why we are presenting and doing this seminar tonight. You may remember that on the 3rd of May, Politico announced that it had obtained an initial majority opinion written by Justice Samuel Alito and circulated in the court on the 10th of February. And this opinion concerned the case Dobbs versus Jackson Women's Health Organization, which is a case that's pending in the US Supreme Court about the constitutionality of a 2018 Mississippi state law that bans most abortion operations after the first 15 weeks of pregnancy. Now, this opinion strikes down Roe versus Wade, the court's 1973 ruling that enshrined the constitutional right to abortion, and a subsequent 1992 decision, Planned Parenthood versus Casey, that largely upheld that right. Now, Politico quoted Alito as saying, "We hold that Roe and Casey must be overruled. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives." Now, maybe it was heeding the words of Alito that on the 11th of May, Richard Blumenthal, a Democratic senator from Connecticut, presented the Women's Health Protection Bill 2022, which aimed at codifying the right to abortion at federal level. It was defeated 51-49, with West Virginia Democrat Joe Manchin, or Manchin, I'm not sure how that is pronounced, voting with the Republicans. So that gives you a background to why we decided to organize this seminar tonight. And as I was saying, Lisa is an associate professor of law at the Thomas Kline School of Law, and she's been a member of the faculty since 2007. And I think her scholarship is really interesting because she focuses on what she calls underdogs in family law, or those family members whose interests are under-recognized, undervalued, and underrepresented. Professor Tucker is also an expert on the United States Supreme Court, not by chance she is here tonight, and has published numerous articles in scholarly journals and the mainstream media about the court as an institution, including Duke Law Journal, the Washington University Law Review, and so on and so forth. Professor Tucker is also the editor of Hamilton and the Law, reading today's most contentious legal issues through the hit musical, a book that was lauded by Washington Post. It defined it as engaging and impressive, and the Los Angeles Review of Books, brimming with insight and originality. And indeed, I already have an idea for the next seminar that we will have with Professor Tucker next year. I would like to address this issue. But without further ado, I will hand the floor over to Lisa. As usual, our speaker will talk for 35 minutes, and then we will open up to Q&A. Let me just remind those of you that are online to ask your questions through the Q&A box and not the chat box. Lisa, the floor is yours.
Thank you. Hello, everybody. And I know I have maybe 15 people here in the room, and I know there are many of you in many other places. I am so delighted to be here. Justin and I have been talking for a long time about my coming and talking with you all, particularly about constitutional law issues and the United States Supreme Court. And then on, as he said, May 3rd happened. And May 3rd, for some, is a fantastic day in history. For some, it's akin to January 6th in the United States, where it seemed like the Constitution was forgotten. I am going to talk first about the opinion, the leaked opinion itself, and what we think we can take from it. I'm going to talk to you about what I think are some key passages in the opinion. And then what I want to do is talk a little bit about the court as an institution and what leaks do to the court and what may come from this, both in terms of the court as an institution. Is it legitimate? You know, are people going to believe in it anymore? And also what may happen in terms of constitutional rights if, in fact, this opinion does become law. So I've been here in Italy for about 2 months. I was in Lucca for a month, and then I've been in Rome for a month. My husband, who is a voting rights attorney in Philadelphia, had never been to Italy, came over to Italy, flew over, got delayed everywhere you can imagine, ended up in like 4 different European countries before getting here. He finally gets here, we go to sleep, and now I'm waking him up saying, my phone is blowing up. Something is going on, and this is the leaked opinion, which came out around 8:30 in the evening US time. So here in Italy, it was very, very, very early morning, middle of the night. There were so many reasons why people in the US were really taken aback by this. And then so many reasons why they weren't, right? So the reasons why they weren't is because ever since the confirmation of Justices Gorsuch, Kavanaugh, and Barrett, and many of you are from the United States is my understanding. So you know that our Supreme Court, and I'm just going to give a little bit of background just for people who aren't from the United States. Our Supreme Court comprises 9 justices. They are appointed by the president, and they hold lifetime appointments. And in recent years, you know, in the last 20, 30 years, the different factions on the court have become more and more polarized. And we really saw this with the election of President Trump, and then the opportunity for President Trump to first replace Antonin Scalia on the court. Although Justice Scalia had died during President Obama's presidency, the Senate, whose constitutional duty is to advise and consent, in other words, they have to confirm Supreme Court justices, had refused to consider the nomination of President Obama's nominee, Merrick Garland. And so the court was an 8-person court for over a year until President Trump nominated a guy named Neil Gorsuch to take that seat. So right away, we have a court that so far is pretty stable. Justice Scalia was quite conservative. He believed in originalism, or thinking about the original public meaning, what these words in the Constitution would have meant to the founders back in the late 18th century, right? And so replacing him with Neil Gorsuch probably didn't do too much on this very, very polarized court, except what do you do when you appoint a Supreme Court justice? Well, a couple of things. First of all, you want somebody who you think is going to take your ideology forward, right? And this is very, very important because in general, in the United States, under our common law, we follow a doctrine called stare decisis. Stare decisis is based on precedent. And that means that when a court has decided a case, usually that decision will stand. Stare decisis means let the decision stand. And it will bind the court for generations to come. So who do you appoint when you're appointing a justice? Well, first of all, you want to appoint somebody who you think will carry out your political agenda. At least that's the way it works these days. But second of all, you want to appoint somebody pretty young and healthy. How come? Because that person is going to be on the court for a long time. Now, we had Justice Scalia. He was older. He wasn't in great health. He had died in his sleep. And suddenly we've got this younger, more vigorous justice on the court. Okay, but ideologically, maybe the court hasn't changed that much, right? Because Justice Scalia is pretty conservative. Justice Gorsuch is pretty conservative, right? Well, what happens next? What happens next is our person in the very center of the court. The person in the very center of the court, Anthony Kennedy, decides to retire. All right, so particularly on the issues we're going to be talking about today, Anthony Kennedy was the hero for liberty. He was the guy who really thought liberty could be viewed pretty expansively in the Constitution. He steps down. He's in the middle. Often on civil rights issues, on privacy issues, he votes with the liberal end of the court, right? Well, now what does President Trump do? President Trump appoints another conservative, Brett Kavanaugh. Okay, so now we have taken the court a little bit to the right, haven't we? Right? We've taken the court a little bit to the right because Kavanaugh is now more conservative than Kennedy. All right, then the nuclear bomb goes off, figuratively, and the news, and again, my phone lights up when major things happen at the Supreme Court, and we have a rule in my family, no phones at the dinner table. And my phone is going crazy, 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 crazy. I finally get up. I think someone has died. Well, in fact, they have, and it's Ruth Bader Ginsburg, right? And this was very, very impactful. First of all, because she had been really the trailblazer and stalwart defender of privacy rights. And second of all, because she was on the left wing of the court. And now Trump was really going to have the opportunity to take the court right. Now, if she had lived for just a few more months, she would have lived to see Joe Biden come into office and he could have replaced her. And clearly that was her goal. We can talk about Justice Ginsburg in the Q&A. People have very strong opinions about whether she should have retired when Obama was still president or not. I have some thoughts on that if you want to talk about it. All right. So now we have basically 6 conservatives, 3 liberals on the court, right? And the question that everyone asks you if you're a law professor or a lawyer or a Constitution person or a Supreme Court expert or an American, right? Just an American is, what happens to Roe? What happens to Roe? Is Roe gone, right? And starting last year, or I guess it's a year and a half now since Justice Ginsburg died, what happens to Roe has been the question at the forefront of everyone's minds. Now, most of us said, yeah, the votes are there to overturn Roe, to take away this right, but will the Supreme Court really act so drastically? And the prevailing view was that the Supreme Court would chip away at this right little by little. Maybe they'd start by saying, well, the right still is there in the first trimester, but at 15 weeks. That's too long. Maybe they would start upholding more and more restrictions. This one that came up in Whole Women's Health a few years ago about having to have like a surgical suite in an abortion clinic, right? Things like that. But surely they won't do away with it altogether. And then we have May 3rd. So now that I've given you the background of the story, I know it's a story that many of you know already, and perhaps some of you, didn't know as well. Let's take a look at the opinion itself. Now, I'm not seeing my PowerPoint here. Forgive me. It is? Oh, you just put a slide on. Yeah. Oh, I'm sorry. Yeah, it's not advancing. Oh, forgive me. Okay. Thank you.
Why not?
Okay, there we go. Okay, so the opinion that drops, first of all, it drops on Politico, which is so interesting in and of itself. What's Politico? Politico is an American left-leaning political site, just like it sounds like, and it's very highly respected. It's very legitimate, but the New York Times, it ain't. Right? Wouldn't you think if you're leaking something of this magnitude that you would go to the New York Times or maybe the Washington Post or maybe the Wall Street Journal, the huge flagship papers in the United States? But no, it's Politico. So that's the first thing we all look at. Like, what is this all about? How do they have it? Could it possibly be legitimate? Right? And then people who know the court started looking at it and saying, this sure seems legitimate. And so what this seems to have been, and what Chief Justice Roberts confirmed a couple of days later as being authentic, is the first draft of the majority opinion of the court, drafted by Samuel Alito and circulated in early February amongst the justices. Now, how does this work? Let me explain this real quickly for those of you who are not familiar with the process. Immediately after the justices hear oral arguments in a case, they will go into a secret room that looks an awful lot like this one. It's got a big oval table. They have assigned seats. They have blotter paper. They don't have their spittoons in there. Those are up on the bench, right? But they do still have spittoons, right? And they go in there, and I sometimes call it their bat cave, right? They go in there and no one's allowed in there except for them. And they discuss the case and they take a preliminary vote, all right? And then the most senior justice in the majority assigns a justice to write the majority opinion. But it's not over yet, because what happens then? Well, then that justice to whom it was assigned, which seems to have been Justice Alito, right, will write a first draft, and it gets circulated amongst the justices. What do you guys think, right? And the problem with that is that once you've drafted it, you may have a whole lot of people saying, no, I'm not going to sign on to this unless you change this, or I really don't like this part, or you're going to have to modify this part, or I think this goes way too far and actually I'm deciding to change my vote, right? And so this early draft seems to have been the first opportunity for Justice Alito to talk to the other justices, and they still do it at the Supreme Court in print with little carts that they wheel around. It's kind of funny, okay? They actually wheel these things around and put paper copies on all the justices' desks. But what's so weird is that this thing is dated early February, but we're in early May. Why are we seeing this early February draft? And I want to talk about that a little bit more in just a minute. But when you start to read this opinion, it doesn't take very long. It just takes a couple of paragraphs to see how earth-shattering this is. It's earth-shattering no matter which side of the abortion debate you're on. So this is the first sentence. Abortion presents a profound moral issue on which Americans hold sharply conflicting views. All right, so the first thing that stands out to me here is the word moral. Moral. We lawyers like to say we're not so concerned with moral, we're concerned with text, we're concerned with, you know, how the law plays. Like, we don't worry so much about morality most of the time. At least that's what we say. Because Justice Alito is going to go on to say, this is all about the text of the Constitution. But where does he start? He starts with morality. And then where does he go? The second clause says, on which Americans hold sharply conflicting views. Okay, well, if you're going to be talking about the text of the Constitution for the rest of, you know, this 94-page opinion, why are we talking about what Americans think? Why do we care? Aren't they acknowledging what a hot button issue this is? And even though he says later in the opinion, this is really a political issue that should be left to the legislature, it seems like he's bringing those politics pretty explicitly into the court, importing them, right? So then he says, speaking of Roe, and I'm just excerpting, even though the Constitution makes no mention of abortion, the court held that it confers a broad right to obtain one. That's what Roe said, right? That the Constitution guarantees a right to terminate a pregnancy. But this is so interesting. Even though the Constitution makes no mention of abortion. Well, why is that so interesting? Yeah, the people who really like to look at texts and call themselves textualists say it ain't in there. Do you guys know, like, this is an Italian kind of joke. Like, in the US, we have this spaghetti sauce in a jar that's called Prego. And they show you putting like tomatoes in and celery in and stuff that, and then like lots of stuff that Italians wouldn't put in. But then their slogan is, it ain't in there, which is like high fructose corn syrup and I don't know what else, right? So it ain't in there, right? It ain't in there. He's saying it ain't in there. Well, that's okay. That's true. It's not in there. But at the same time, there are zillions and zillions and zillions of rights that we have that aren't in there. Why is that? because the framers couldn't write a comprehensive document. They couldn't for two reasons. One, like they couldn't sit down and write a document that would cover every single eventuality, even of their time. And two, they wanted this to be an enduring document. And the way you make a document or any law enduring is to be somewhat specific, but also somewhat general, understanding that in the future, things are going to happen that you haven't anticipated. And of course, where we see that most vividly right now is with the Fourth Amendment, reasonable searches and seizures, unreasonable searches and seizures. What does reasonable mean? Well, I'm going to tell you something, guys. Fourth Amendment does not mention the internet. And yet we have interpreted the Fourth Amendment to prohibit certain kinds of searches and seizures with the internet, right? So he seems to start off by hanging his hat, and all through this opinion, it makes no mention of abortion. Absolutely true. I will concede that point. There is no mention of abortion in there. So then he says, at the time of Roe, 1973, 30 states still prohibited abortion at all stages, and about a third of the states had liberalized their law, but Roe abruptly ended that political process. Okay, so about a third of the states had liberalized their laws. To me, that seems like a hot button word, because that lib word in the US is a pretty hot button word. But then look at the next sentence. It imposed the same highly restrictive regime on the entire nation. All right, wait a minute. I'm a little confused by that, because what Roe said is we aren't going to restrict access. You get to have access. And what Alito is doing is trying to wordsmith, trying to craft an argument that it was highly restrictive not to restrict. And this is going to be the guts of his argument as he goes on. See how here in his statement he has states capitalized? States with a capital S. This is going to lead into the states are really important independent entities, and they should be able to decide this through their political process. We at the court should not be restricting them. All right, so here we go. This is a couple pages in. We hold that Roe and Casey must be overruled, and here we have the main reasoning of the opinion that I want to talk about. The Constitution makes no reference to abortion. We've seen that first. No such right is implicitly protected by any constitutional provision. That's sort of interesting. We'll get to that in a minute. That provision, the 14th Amendment, has been held to guarantee some rights that are not mentioned in this Constitution, but any such right, and guys, this is where the argument goes, must be deeply rooted in this nation's history and tradition, and implicit in the concept of ordered liberty. All right, so two big concepts here. And if you all have ever studied the Constitution, these are going to sound familiar to you. One, deeply rooted in history and tradition. Deeply rooted. And number two, liberty. And not only liberty, but he's going to have this weird argument about ordered liberty. Ordered liberty versus regular liberty, right? And he says the right to abortion does not fall within this category. So see, here are two main arguments: deeply rooted, ordered liberty. All right, well, he goes to liberty first. And he says, well, okay, so the people who supported Roe and Casey said that liberty actually has this subpart. And the subpart for liberty is called privacy. Privacy ain't in the Constitution either. Doesn't say it, word doesn't appear. But the privacy right, and we're going to talk about this in a minute, actually encompasses a whole bunch of other rights that have been with us for a long, long time. So he says, Casey described it as the freedom to make intimate personal choices that are central to personal dignity and autonomy. Okay. And then he says, it's okay, you can totally think whatever you want, but this isn't liberty the way we think about it in the Constitution. All right, so that's super interesting, isn't it? Because liberty is a pretty general word. That's true. And in order to establish a bunch of rights that we have established under the 5th and 14th Amendments, we use that word liberty a lot. And remember how I said Justice Kennedy was in the center of the court? Justice Kennedy was our liberty guy. He loved this word. He put it everywhere, right? And so different people are going to define liberty in different ways. And what Alito is saying is, no, we don't think that making intimate personal choices central to bodily integrity and autonomy are part of liberty. And no, we don't think, this is really important, Roe termed this a right to privacy and liberty, but then he says, this isn't liberty. Well, hold on a minute. We're not just talking about abortion now. So let's talk about that in a minute. So here are our key words. All right, now he says, now we're going to get to history and tradition to figure out what liberty means. And he says the term alone doesn't give us much guidance. It's capacious. And then he does what you do if you're making an argument and you want to have like people go, oh, yes, 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 yes. He cites to somebody that we all think was cool, Lincoln, right? Lincoln once said, we do not all mean the same thing. True. Okay, so now he says, in interpreting what liberty means, we have to guard against our natural human tendency to confuse what that amendment protects with our own ardent views about the liberty that Americans should enjoy. All right, so we're defining liberty, but we can't do so in a way that feels intrinsically correct. We can't do so in a way that precedent has already told us, no, 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 all of that is wrong. We've got to go back to what was his first sentence? His first sentence was moral traditions, right? The morality and the deep divisions in this country. And so he says, Roe's defenders say, this is just like some other privacy rights, intimate sexual relations. That's Lawrence, if any of you are familiar. Contraception, marriage. But abortion is fundamentally different because in abortion, we have got, and look at this, he quotes from the statute, fetal life and an unborn human being. Okay, so what he's saying is, we don't just have one person's liberty that we're thinking about. He says it explicitly here. We have two people's liberty that we're thinking about. And so when there's a conflict, we have to figure out how to resolve that conflict. And so he says, this is hilarious to me, Roe has had damaging consequences. Far from bringing about a national settlement of the abortion issue, Roe and Casey have inflamed debate and deepened division. All right, it is certainly true that there is enormous debate and enormous division around Roe and Casey. But no matter which side of this issue you come out on, it's hard to imagine a world in which Dobbs, this new decision, isn't going to inflame debate and deepen division. He's almost saying, you know, we're going to try to fix this debate and fix this division. This ain't going to do it, Justice Alito. This is just going to make things more inflamed. And then he gets to deeply rooted in our nation's history and tradition. First, he does this really long historical analysis. And he does this whole analysis of laws after quickening. Quickening, before we had ultrasound, before we had reliable pregnancy tests and stuff, was when the woman could feel the fetus moving, right? Which usually happens, he says 16 to 18 weeks. That's kind of early. It's more like 20 weeks usually. Okay, he says this was a crime. He also says, well, it's true that there weren't really criminal laws pre-quickening, but that's okay because they didn't say it was okay either. So since they didn't say it was okay, that makes it not deeply rooted. And he also claims that Justice Blackmun, in writing Roe, and the advocates for abortion rights actually mischaracterized history and lied about what the former law had said. And then he says, the inescapable conclusion is that a right to abortion is not deeply rooted. Instead, there's an unbroken tradition of prohibiting abortion. Once you've got deeply rooted in the history and tradition of this country, you've got a real problem, because liberty is defined by those two things, right? We've got to have this idea of deeply rooted, and then we have to have this idea of ordered liberty or interests aligning. So in essence, he does several things. First, he tells us precedent doesn't matter. He has a whole section. He says precedent doesn't matter. And he gives a huge long list of cases which have overruled previous Supreme Court cases. The case that he likens this most to is Plessy v. Ferguson, which is the big stain on it's the separate but equal case in the United States that Brown v. Ward overruled, right? But then he goes on to say, you know, it is true. We're supposed to abide by precedent, but we have all these times when we haven't, and we're allowed to not abide by precedent. We're allowed to undo stare decisis if the opinion was just so bad. And this opinion was so bad. All right, he then says it's not deeply rooted, and this isn't a liberty right, because we have the conflict between the unborn human being and the woman who is acting as the vessel, some would say mother, right? So, I mean, it totally depends on which side of the issue you're on. I mean, I'm pretty obvious about which side of the issue I'm on, but at the same time, I want to acknowledge that there are good arguments on both sides of this, right? So I guess the question is now, and I'm getting towards the end of my time, what happens to the Supreme Court as a result of this? Either as the result of the leak itself, or as the result of a final decision in Dobbs that would be something like this. We don't think this is the final thing, right? We think there'll be amendments, but we don't know what those amendments are going to look like. Well, I think a couple of things happen. First of all, we really ask questions about the legitimacy of the Supreme Court. Remember, President Trump appointed 3 justices. Those 3 justices are reported to be in the majority. The leak included that those 3 justices voted to overrule Roe. And so the legitimacy of the court has forever depended upon this idea that the courts were independent of politics. Probably, a fallacy, but still, this lays it bare for everybody to see. And if you think that the judicial system is inherently political, you wonder how legitimate the court will be viewed. We also have a problem with the rule of law and this idea that we listen to our courts, we follow what our courts do, we don't have a military state, we don't have anybody, locking us up and saying you have to do these things. We willingly follow the courts. But if we start to think that the courts are political, or if we're willing to just say, screw it, as they did on January 6th, we've got a real problem, because once the rule of law is gone, once this tradition and this inherent American value of we do follow what the courts tell us to do and the legislatures, we've got a big problem. How do we ever get that back, right? How do you corral that back in? The politicization of the court. And then I put in handshakes here. One fun little trivia fact for you guys is that before every oral argument, all 9 of the justices shake the hands of each of the other 9, which, if I'm right, comes to 72 handshakes, because it's 9 times 8, so 72 handshakes. And this is their way of saying to each other, we're all colleagues, this isn't personal, we're really trying to do the best job we can here. But again, is this going to foster some really deep divisions in the court? From what we're hearing, there's already a lot of hoopla at the court about the fact that the leak happened in the first place and who leaked it. So I guess the next question is the leak the big deal? Or is the draft opinion the big deal? Or are they both a really big deal? The leak is almost unprecedented. we have not had a full draft opinion leaked before. We have certainly had information leaked about which way the justices were going, even what some of their reasoning was going to be. But having the full text there and then having Chief Justice Roberts confirm, yep, this is real, that is what we say in the law, a matter of first impression. And Chief Justice Roberts was, if you'll forgive my language, pissed off, right? He's like, no way, this undermines the work we do at the court because our court is confidential. And if all of a sudden people can leak with no repercussions, it's going to be really hard for us to do our jobs. And we need to do our jobs because of that rule of law thing and because of the handshake thing. He's ordered an investigation. Who knows what will happen? There'll also be questions about, will the justices want to communicate with each other? Will they confide in the people who help them, like their law clerks? Can they actually do their job if they're always worried about a leak? And then there are going to be questions forever about why. What was the motive? What did the leaker hope to gain by leaking this opinion? And we can talk about that more in the Q&A. There are lots of theories about that. Why leak it all? Why leak the February draft? Because there certainly has been more than one draft by now. And will the draft serve to hold the majority in place? Because it'll look even more political if one of the people that we know is in the majority suddenly says, actually, I'm going to leave the majority. So last slide, what likely happens now? Well, it's going to go to the state legislatures if this in fact becomes law. And there are many, many states that have laws ready to go. Upon the overruling of Roe, the laws will go into effect. And these might be laws like the one in Texas that provides a bounty for people who find a woman who's had an abortion or anybody who's assisted with an abortion. Some people think that even means like the Uber driver who takes you to the clinic. Access to abortion is going to be at risk. I live in Pennsylvania. In Pennsylvania, it's very, very unlikely that this right is going to go away. Our state legislature will likely continue to allow abortion access in Pennsylvania. But for example, I live in Philadelphia, the biggest city in Pennsylvania. We have two clinics. So let's say that I have 4 daughters. Let's say one of them needs to get an abortion, all right? The problem won't be that she can't get one in Pennsylvania because the law will say it's okay. But the problem will be that how hard would it be to get an appointment because we're going to have people coming from Ohio or Mississippi or Arkansas. And in fact, arrangements are being made right now to house people who need to come from other states, right? And so no one opens new clinics anymore. People are afraid of getting shot, right? And so abortion access, even in states where it is still legal, is going to be very fraught. And then last, and then I'll leave it here, Justice Alito pretty explicitly says, yeah, Roe said there was this right to privacy under the due process guarantee of liberty. But yeah, that ain't there. It ain't in there. And he seems to really mock that idea. Well, what other rights come up under privacy? Our right to contraception, our right to marry a person of our choice, whether that is a person of another race or the same gender or anyone else, our rights to procreate, right? And they can't take that away from you, right? So if you want to have children, they can't sterilize you against your will, for example. Lots and lots and lots of rights that if privacy is suddenly at risk, all of these rights could go away too. Now, Alito says in the draft opinion, oh yeah, we're not going after any of those. Don't worry, they're all okay. But after everything that's happened politically, everything that's happened with the court, and then this leaked draft, it's really hard to predict what will happen in the future. I'll leave you with one final thought, and then I'd love to hear your questions. I was just at a meeting last week of the American Law Institute, which is a group of judges and professors and lawyers who help advise legislatures on what the law should be. And we've just come up with a draft document about sexual harassment on college campuses, which could include sexual harassment or sexual assault. basically anything that a student would perpetrate against another student. And someone went up to the microphone because one of the things that was advised in this document is we have to keep very careful records in order to protect all parties. And somebody went up to the microphone and said, if we keep really careful records, then those records can be used because, you know, sometimes when there's sexual assault, a pregnancy results. And then if we have these records that a sexual assault took place, then there's the likelihood of a pregnancy, and we could be putting women at risk of prosecution or, you know, being offered up for bounty. And to me, that was really, really profound. I have 3 daughters in college right now. I would certainly want them to feel free to report without risk of this coming back to bite them in the long run. So I hope that that was somewhat informative and helpful. I would love to hear your questions. I could talk about this like till tomorrow, so you're gonna have to make me stop when you're ready. We'll stop the share. Yeah, I'll stop the share though, so we can see us. Right. There we go.
Okay. Thank you very much, Lisa. That was super. Okay, I think we have a question in the chat. But before we go to the question in the chat, I'm going to give the priority to those that made the effort to come here and be in person. So, is there anyone that would like to break the ice?
Would anybody be offended if I took my jacket off? No. It is so warm in here. I want to look professional.
Oh, you made me feel
but...
awful. I didn't ask.
Oh, no. But you're not the speaker, so that's better. It's been so hot.
I have a quick question.
Of course.
How did Chief Justice Roberts vote?
So it seems that he did not vote with the majority.
Okay.
It seems that he did not. At least his name wasn't one of the ones that was leaked. Now, a big, huge point of speculation is that one motive for the leak could have been that he's trying to recruit somebody from the majority to say this goes too far. And maybe that it would be so shocking and everybody would be like, oh my God, right? Because, I mean, Alita's language is pretty harsh in this, that somebody who's working with Roberts or one of the liberals is trying to use this as a way to draw somebody else from the majority over to their side.
Could it conversely have been an attempt to bully him into voting?
Absolutely. But they don't need it because there are 5.
No.
Now, they would like to have him because, you know, he's the figurehead. And they've been there's been lots of concern on their end of the court that he's been voting with the liberals more than they would like, right? So yes, they would love to have him, but they don't need it. Yeah.
Thank you.
Susanna.
I have a question.
Yes.
And it maybe also is to Justin, because I was wondering about Italy.
Yes.
We're here in Italy.
Yes.
And it seems, and also morality. So I think that abortion is more legally available in Italy in a more clear way than Roe versus Wade. And yet I've heard that the morality issue comes into play when you get Italian doctors that maybe they've been like obiezione di coscienza about even being willing to give an abortion.
Yeah.
Is that the case?
So I looked up a little bit about Italian abortion law before I came, and it looks like very routinely up until pretty late in the first trimester, you don't have to have any reason. But certainly in the US, and I have heard this in Italy as well, having this conscientious objection, particularly on religious grounds, they do have to find another provider. In the US, basically people volunteer to be providers, and it's unusual to just go into a hospital and say, I want an abortion. But my understanding is that it does take place in hospitals here, and that many hospitals are run by the Catholic Church. So yeah, it could be a really difficult access point. What we're seeing more and more in the first trimester in the US, and it seems like here from the language that I was reading, is medical abortion rather than surgical abortion. So basically with medication. And it seems like Italy recently revamped its laws on medical abortion. You used to have to go into the hospital for 3 days to have a medical abortion. It's basically like having a heavy period in your first trimester. And so they recently allowed for women to self-regulate at home and have the medical abortions.
I'm just going to add to that. Yeah, obviously the idea of having conscientious objectors is the balancing of different rights. So here, the reason behind the idea that some doctors can object to carrying out an abortion is in respect of their freedom of religion. Now, of course, this could open up a debate in itself, but here we have a balancing of rights taking place.
Sure.
Now, I can add to this that this is a non-legal argument, that there is an abuse of this conscientious objection, because there are a lot of doctors that maybe are probably pro-choice, but don't like carrying out abortions, and therefore there are sometimes in certain hospitals in certain parts of Italy difficulties being able to carry out abortions. So the issue is controversial, and there's a debate. But of course, this leads me at this point, allow me to ask you a question, because the issue, seen from an Italian point of view, or seen from more in general civil law systems, is why is this issue being dealt with by the Supreme Court? Why is abortion and the right to have an abortion been based on a decision of the Supreme Court rather than on federal legislation?
Right. So that's a really tough one. And it's really tough right now because we also have a very evenly split legislature. So the Senate is 51 to 49 right now. I think it's actually 50-50, I think, with Kamala Harris being able to vote, cast the deciding vote, right?
Yeah.
So the problem is you really can't get the federal legislation passed, right? And that's what we just saw a couple of weeks ago. In states, and I'm learning as I've been in Italy longer that regions of Italy also have personalities the way that they do, regions of the US have personalities. There are certain areas of the US that will never, ever, ever, if given an option, legalize abortion, right? So you want to go to the federal government, but there are going to be two problems there. One is one senator changes, it gets repealed. And we're anticipating with the midterm elections coming up in November that we're going to lose seats in the Senate. And second, there are some federalism concerns with the federal government taking this action.
Right,
can the federal government rule in an area that has been traditionally reserved for the states? And again, we saw that capital S states from Justice Alito, right? Sort of personal decision making and family type issues are typically state law in the United States, and we have two concurrent systems. So certainly the argument would be made that if the federal government did pass this act that they're trying to pass, then it would be unconstitutional on federalism grounds. You end up in the Supreme Court again, and you end up with the same result. So what people are, some people project is that polls do show that the majority of Americans want there to be at least some right to abortion, right? At least some. Some people want more restrictions than others, but at least some. And so it may go the way that same-sex marriage was going before the Supreme Court declared that to be marriage equality, a constitutional right, that maybe the political landscape has changed enough that in more areas than we think, it will become available. It seems pretty unlikely. Attitudes about marriage equality change so rapidly in the US, and we have 50 years of battles over abortion with people being absolutely entrenched. So we're going to be watching very closely over the next, 3, 4, 5 years. Yes.
Caroline.
Hi, thank you for being here.
Thank you.
Caroline. My question is about the confirmation process itself. And I remember that these questions came up, and if I remember correctly, the responses were, well, this is settled law. Yeah. We won't be attempting to undo it. And I'm curious, because this is nationally televised, everybody watches, what recourse there is to hold prospective justices accountable for or hold them to their word when they say something in front of the Senate for a confirmation, or if that's just sort of part of the deal, is you assess them as a person and then let them make their own decisions when they make their report.
Yeah, so such a good question. I may be wrong. I need to go back and look at the transcripts to be sure. But I think that you are absolutely right that they said it was settled law. but I don't think they went so far as to say, I won't be seeking to undo it. So yes, they acknowledged that it was settled law, absolutely. And in fact, Susan Collins, one of the senators who crossed the aisle to vote, has said, but they promised, right? Then she voted against the federal act. So yeah, but there has been a tradition since Ruth Bader Ginsburg that nominees for the Supreme Court will not answer questions about how they would decide cases if they were confirmed to the court, issues that might come before the court. And saying it's settled law is absolutely true. What they fail to acknowledge is exactly what Justice Alito says in the leaked opinion. Yeah, stare decisis, that means it's settled, except we can undo it when we want to, right? So they didn't lie exactly, but they didn't tell the whole truth either. And it's hard to imagine. I mean, Trump made as a campaign promise that he would nominate justices who were anti-Roe, right? Who wanted to overrule Roe. And so it's hard to imagine that in the conversations that Trump had with his nominees, that this issue didn't come up and that they didn't discuss exactly that. We'll never know. That's the kind of thing we'll never find out. Yes.
So you brought up this really interesting point about respect for the rule of law in the United States. I was wondering, from a historical perspective, history doesn't repeat itself, but perhaps it rhymes. So have there been points in U.S. constitutional history where there was potential discrediting of the rule of law? I'm thinking specifically of when presidents used to change the number of seats on the Supreme Court.
Sure.
Why it has become accepted that it's a nine-member court.
Yeah, such a good question. So first of all, the conversations about expanding the court have become very vibrant again in the U.S. And it's set by Congress. So Congress can decide to change the number. It's not in the Constitution anywhere. Certainly there have been times, FDR had his court packing plan, right? But we've seen other times when the courts have spoken and someone has refused to obey the law. I think the image that most of you might be most familiar with was after Brown, having to call out the National Guard to escort children into school because governors were saying, we won't do it. We will not desegregate the schools, right? So there have been attempts, right, to say, no, we don't have to do this, but people have always fallen back in line, right? And even though I don't think the average American would be able to say the rule of law and what that means, they understand this idea that we're governed by a common agreement, right? We all buy into this agreement that we're going to do what we're told, even if we really hate it, right? Or else we'll suffer the consequences. But if you start to have, if January 6th happens again, or if people really rise up against this, who knows? I mean, who knows what it'll take to break that? And I really do think that once it's broken, it's broken. You can't put it back together again. And then what do we do? Right? Then what do we do?
Okay, let me go to the online. I have a question by Professor Arthur Appleton, who teaches international trade law.
Hello, Professor Appleton.
I'll start with the last. He says, you're right to be concerned about Griswold and the consequences.
Yes.
Okay. And then his question is, does a state have jurisdiction to criminalize travel across state lines to obtain an abortion?
Such a good question, right? I mean, we have a right to travel under the US Constitution. That's one of our most fundamental rights, right? The right to travel, the right to vote. These are just absolutely sacrosanct. So it's hard to imagine that a state could prohibit your right to travel. But I would certainly think that the issue would be debated if you do something that is, prohibited in this state. Like, can you still face consequences when you return to the state? Right? I don't know the answer to that question. That's tough. What do you think, Professor Appleton?
If you're there, Arthur, I don't think no.
I mean, we would have to turn him on, which I can't.
Okay.
Do.
Well, maybe he'll type.
He'll type.
Yes.
Type, Arthur.
I want to hear what you think.
In the meantime,
yes.
Angelina Tchaikovsky, an intern of CCSDD, asks, okay, I'm summarizing her question.
Okay.
What happens to the role of and the nature of the Supreme Court as an counter-majoritarian institution?
Yeah, that's very difficult, right? Yeah. So does everybody know what we mean by counter-majoritarian? Okay, so basically what that means is that a justice of the Supreme Court is appointed without like a public vote, right? We don't elect our justices to the Supreme Court. And so very often the Supreme Court might act in a way that perhaps the majority of Americans would not agree with. But where we've typically seen this happen in recent history is, for example, the civil rights era. So typically, this counter-majoritarian purpose has been to protect the minority constituents who would never be able to override the majority in an elected system. So that where there are rights, and they are in the Constitution, that the Supreme Court can protect those even when they're not very popular rights, right? And there are lots of rights in the Constitution that aren't very popular. There are a lot of people who think, you know, somebody commits a crime, the police should be able to do whatever they want in order to, you know, bring them to justice, right? But that's not what the Constitution says, right? And so very, very often the court has acted in a way that would serve to protect unpopular, at the time, populations against a very vocal and powerful majority. So what happens to that? I think the court, I think Alito would say that's exactly what they're doing now, that there is this very vocal population that no one is listening to. And you remember what he said? He said the highly restrictive regulations of the entire nation. There are some people who feel like they are the oppressed minority and that they need the Supreme Court to help them. And that's exactly what the Supreme Court is doing here. And I mean, that is legitimate. That is true. It's just, you know, is this the appropriate role? I don't know. The Supreme Court obviously thinks so.
In the meantime, Arthur has replied, I have no idea.
He's no idea. Arthur, let's chat. Email me. I'd love to chat.
Okay, Colin has an interesting question. Does the Alito draft make any claims on the beginning of human life? Does he make any constitutionally based arguments about it? It seems he claims life begins at conception. If that is the case, do you see this also affecting the world of in vitro fertilization or life insurance or the definition of homicide?
Wow.
Does that also affect the definition of the end of human life?
So good. So Alito specifically does not, but he does say he has this section where he says, some people think it starts at, you know, conception. Some people think it starts at, you know, when it can survive on its own. Some people think it doesn't, it's not life until it's outside the womb and can survive, right? But he does have a lot of things in there where he talks about interests that might also need to be protected. And he talks about things like fetal pain, for example, as needing to be, you know, protected against. So he never actually says that. What he says is that states can go ahead and decide for themselves, but nor does he dismiss those ideas, right? So he you know, he does keep bringing up this moral thing. So yes, I think if this becomes law, then defining a fetus as a human is the obvious next step. And in fact, you know, this Mississippi law calls it an unborn human being. And then we do have, yes, it's the slippery slope. Yes, you kill a pregnant woman, it's 2 murders. Absolutely. I mean, but then I think, you know, pregnant women are going to be excited because they can drive in the carpool lane. So, you know, you get the benefit too, don't you? Yes, I think that there's a whole set of regulations and laws that come crashing down. But at the same time, that happens whenever there's a big change. For example, when marriage equality was established in Obergefell in 2015, there were over 900 federal laws that referred to marriage as between a man and a woman in some way. And so there was this whole legal structure that had to be, you know, whether it was the IRS or whether it was the military or whatever it was, everything had to get amended because this had been the common definition. And so I think that's what happens again. Once a fetus is a human, then there are going to be all kinds of places that we don't even anticipate it that are going to be affected. Yes.
Okay, I've got another question from Professor Mark Gilbert, Grove Haynes Professor of History here at SAIS. and he's anticipated something I was going to ask you.
Oh, good.
If the leaker
Yes.
was proved to be a justice or
Yes. someone
very close to a justice, would that justice have to resign? And more generally, what would the consequences
be? Is he asking
be?
if Ginny Thomas was the leaker? Is that what he's
I don't
asking?
know.
Are you asking Professor Gilbert if Ginny Thomas was the leaker? No, absolutely not. There is no code of ethics for the Supreme Court justices. There is currently a lot of movement for a code of ethics for Supreme Court justices, but currently there is not one. The code of judicial ethics that applies to all other judges in the United States does not apply to the Supreme Court. So they can do whatever they want. No, certainly if it's someone close to if it's someone close to a justice in an employment context, that person's gone and that person's career is ruined. If you work at the Supreme Court, it is the biggest career deal, right? Being a law clerk, for example, or being an assistant to a justice is the biggest deal, and it sets you up for life. Everyone will. I mean, for example, for a Supreme Court clerk, a law clerk who's a couple of years out of law school, if they go to a law firm, they're getting like $300,000 bonuses, signing bonuses right now. And then people want to offer you jobs for the rest of your life, right? It's a very big deal. So if the leaker is not a justice, this leaker has taken an enormous, enormous risk. And you've got to think that with today's digital capabilities, unless this person walked a paper copy over to Politico, still there are going to be cameras, right? Like somehow they're going to figure out who this is. Or maybe it's deep throat and we don't find out until the person's dead. I don't know.
So Lisa, let me just follow on to Mark's question. So a justice, there couldn't be an impeachment against that justice?
No.
Interesting.
Impeachment would be for something way more serious. Way, way, way.
So you wouldn't consider this a misdemeanor? Okay.
No, not at all.
What about a law clerk that hasn't done the bar exam?
Oh, that would definitely get reported to the bar.
Right.
And to be admitted to the bar in any U.S. jurisdiction, you go through what's called a character and fitness assessment. A justice saying that you are not of good moral character would probably doom you. Yes, it would probably doom you. It's really hard to imagine that it is a law clerk, but at the same time, if it is a law clerk, we've got to think that that person was authorized by their justice to do it, right? Yeah,
like scandal. Sorry.
Isn't it? See, this is why I'm riveted. And we're May 3rd. My husband's just arrived in Rome. Like, we're going to have a vacation. We haven't seen each other in a month. And I'm just on the computer.
It's actually about the Ruth Bader Ginsburg aspect, which I wanted to go back to. Because she was such an amazing justice that, I mean, and whether or not she should have tried to stick it out through Trump, or
she tried. She died of cancer.
Right. But having had the experience with, I guess she hadn't. Obama had the possibility to nominate someone instead of Kavanaugh, and he couldn't.
Right. So, but she could have done it much earlier.
Right.
Okay. So I see what you're saying. Yes, I see what you're saying.
Why did she save her spot, knowing that her health, even at that time, was not?
No, her health was terrible for years and years and years. So here was what my answer used to be to that question when she was still alive and when Trump was newly elected. People would say, how could she? Why didn't she step down with when Obama was still president and early in the Obama presidency? Because she was quite old, she was, and in very ill health. She had pancreatic cancer and a couple other kinds of cancer, but pancreatic's the really, really bad one. So what I used to say is, look, we all revere RBG. She's the notorious RBG. We all think she walks on water. We trust her judgment. So if we trust her judgment in everything to do with the country, why don't we trust her judgment on whether to retire or not? How can we say, you're making the wrong choice here, Ruth, even though we think everything else you do is perfect, right? So that used to be my answer. You also have to remember that the election of Donald Trump was a shock to everyone. My husband works in politics very, very closely. And on the evening of the election, I had been out poll watching. He was still in election court. And I called him and said, okay, I'm watching TV and I'm looking at the states and I don't understand how this adds up. And he was like, oh, it does, it does, it does, it does. And then an hour later, he called me back and he said, it doesn't, right? Like, I mean, it was a shock even to huge insiders. So she thought Hillary Clinton was going to be the next president. She thought it was fine, right? Hindsight is 2020. I mean, now I say, I mean, hopefully, I mean, when Justice Breyer announced his retirement, it's so clear to me that that was informed by what happened with Justice Ginsburg. We don't know what's going to happen in the midterm elections. We don't know what the Senate will look like. He was preparing for the chance that the Democrats might not hold the Senate and giving Biden plenty of time to appoint his replacement. And I think he learned.
Can I just follow? I know we have a question. Can I just follow on this appointments issue? Some say that Kennedy resigned when he did because he knew that Kavanaugh was going to replace him, and Kavanaugh had been his clerk. And Kennedy was convinced that his sort of doctrines of liberty would be maintained by Kavanaugh.
So I agree with everything you just said, except the last sentence.
Right.
The very strong rumor in Supreme Court circles was that Kennedy said, I will step down if you appoint Brett Kavanaugh. Brett Kavanaugh was super conservative from the beginning. I mean, he worked on the Monica Lewinsky team. You know, there is no doubt that Kennedy, I mean, he was very vocal and very prominent conservative judge. So even if Kennedy thought maybe he could not have been confident in that, and probably was more confident the other way. Yeah.
Yes, go ahead.
Thank you so much for your time. I really appreciate it.
I just love this. And I love that people come out at 6 o'clock at night. To get my students to come out at 6 o'clock at night, I'm so impressed. I'm so impressed.
Well, there's not a full question, but what do you see as the future for women's rights in this? Because it seems like there's going to be more and more repressions and unsafe places for women to seek the needs that they require. And I just, especially with even Jeanette Young talking about the economic impact of this. And what do you see as the future for women?
Low income women, especially.
Yeah.
It's very tied with discrimination and like discrimination on the basis of sex. Yes.
Yeah.
The whole bounty concept.
The whole bounty concept. Yeah. I mean, you know, I grew up in the American South, and my mother used to say, there are two things that's really easy to gain and really hard to lose. And they are extra weight and credit card debt. And I think the third one is hate. And I think that in our country, in the last 6-7 years, hate has become acceptable. Overt hate has become acceptable in a way that it was not for a very long time. And when you have that overt hate being accepted and even celebrated, right? Really celebrated. It's very hard to see how that won't seep into every part of American society for a really long time. So yes, I think there's really good reason to be concerned. And most state legislatures are pretty darn close. And the federal legislature is so darn close right now. And it takes a couple of, you know, changes to really put rights at risk. Yes, and all kinds of things. You know, we have federal laws. I mean, you know, it was so funny. He said one thing that Alito said in the draft opinion was, you know, people say that one reason we don't need Roe anymore because now, like, you know, there are safe haven laws where you can drop your baby at the police station, and also there are laws in place. And he even says for many people, he doesn't try to pretend it's all, where you can have maternity leave and, you know, parental leave and you don't get discriminated on the basis of pregnancy. Well, okay, except that it doesn't apply to everyone, doesn't apply to small companies, doesn't apply to the federal government, for example. It's not paid in the vast majority of cases. I mean, how do you access this right? How do you access this right? So there's a mythology out there about protections that really don't exist, right? And then, you know, what you said about low-income women, I mean, you know, Congress just voted this week on an act to fund or give aid on baby formula.
And they said no.
And they said no. Right. So, okay. It's really hard to make that consistent with, you know, but here we are. Yes. Yes.
Okay, this is a big one, but I was wondering, what kind of, do you think this could trigger a domino effect in different countries as well? In the EU even? Because after all, some cases are still decided on the basis of Roe or so.
Sure.
Right?
Sure. I mean, to the extent, I mean, I think that from everything I've seen, and being here in Italy has been so interesting for me because I love talking to people about how they perceive the United States. So many people really think Biden's terrible here, which is fascinating. I think people here think that Trump was terrible, but they think he was just a clown and a one-off, and like, that'll never happen again. Like, that was a crazy, weird thing that happened. That's the impression I'm getting anyway. So I think that the United States' position on a pedestal as kind of a global leader is shaky. But at the same time, I agree with you. If the United States does away with this, then why would any other country, you know, I mean, certainly marriage equality has really followed after the US in a very, you know, a very robust way. Who knows? I mean, at the same time, the US still has the death penalty, and there are like 2 other countries in the world that have the death penalty, and one of them's North Korea. So the rest of the world hasn't followed that. So it's hard to say.
Slightly different discussion.
Yes.
More on the movement that is of the far right movement in the US. I mean, it gives a lot of power to them, right? Pro-family, pro-family movement in the US. And I'm just wondering why other countries in like Latin American countries like Argentina, Uruguay, that have much better laws are not having a spillover effect in the US. Like,
I wish I knew. Because in that same pro-family, you know, I mean, is anybody anti-family? I mean, I'm so pro-family. Like, I have a big family. I love my family. I'm huge on family, right? But, you know, the same pro-family, like, have the babies is, you know, but if you need help because you can't feed all the babies, you know, you can't get welfare, right? So I think that pro-family is a much bigger concept than the far right is making it out to be. I think there's been a lot of research done on why has Fox News been so successful? Why have they been able to convince people so wholeheartedly? And they're really, and why wouldn't other countries' examples be more persuasive, right? And there really seems to be some cognitive dissonance that people sort of believe one small thing, and then they've kind of gotten into this social groove. And then as more things get told to them, they're just going to buy into them because they're trusting the sources, right? And also, it's very hard to say to yourself, oh, I've been believing this thing for a really long time, and wow, I was actually wrong. That's very hard for humans to do. So I think it's partially the messaging, and it's also partial. I mean, there's been tons of research done on social media also, and what you see on social media. So you and I might see completely different things, like how are other countries handling this, and you know what are some successful ways of making sure that women still have rights and stuff like that. We might see all that kind of stuff through social media because of the way that we interact on social media, whereas people on the far right are getting completely different messages and completely different content based on the algorithms. So to me, that's really, really interesting.
And would it have any impact on the global gag rule?
On the global
Gag rule?
I don't know what the global gag rule.
So it came back during Trump's regime, and it prevented all U.S. international agencies to fund reproductive rights related programs everywhere else.
Okay, I just didn't know that was what it was called. Yeah. Everything, it's like a teeter-totter right now. Everything is right here, and both sides are so afraid that it's going to tip one way or the other. I mean, it used to be until, was it Gorsuch, or was it the one before that, which would have been Kagan? It used to be that you needed 67 votes to confirm a Supreme Court justice. Like no one would ever manage to get confirmed now because you cannot get 67 votes, right? Like it's just like 1 vote, 2 votes, and that's going to be true for everything, right? And that is why no matter what your political beliefs are, if you are an American citizen, even abroad, voting is so important. Getting out and voting is so important. My husband just won a big case in the Third Circuit a couple days ago that is turning on 270 votes, right? 270 votes that are going to get counted that weren't before, that could change everything. And that's how thin the line can be, right? So getting out and voting, getting your friends to get out and vote, and helping other people vote. One thing that's happening a lot in some places is that they're restricting the right to vote in very non-obvious ways. So for example, in Philadelphia, we do tend to have long lines at the polls, right? There's a whole system in Philadelphia, and it's not, by the way, it's not partisan, that when there are long lines, they send DJs out, they send pizzas out, they want people to stay in line and can't cast their vote, right? They make it to where it's not awful to have to stand in line. States are starting to say, you cannot serve food to people in line. You cannot, just dumb things like that that make it really hard, right? Make it really, really hard. Besides the things that we all know about, like voter ID laws and things like that, right? Just how can you make it to where people want to come vote and want to stay and want to do it every single time? And let me tell you, local and state elections are equally as important, not just the big, November federal elections, but who your trial court judge, your state trial court judge is, who your state senator is, who the head of your city council is. All these things weigh into all the things we've been talking about. And again, I want to emphasize that even though I have pretty strong political views, I believe that all of us should be expressing our views and all of us should be voting and all of us should be working to make sure everybody has what they need, right? And the only way for us to do that is to vote.
Another question?
I have one more question, yeah. To go back to tribal language that the judge used, do you have a fear that American law is going more to include religion?
Oh, yes.
Like a moral thing.
Oh, yes.
It doesn't seem to be.
Oh, no, it's disappearing. Absolutely, it's disappearing. Yeah, it's very difficult.
For that, if someone does try to take the language, the true language of the Constitution, and say moral, and how do you?
Well, this is what Justin was talking about the balancing of the interests. So typically the balancing of the interests has resulted in there being a pretty firm line between church and state. So let's say, for example, prayers at a high school football game, or, a pharmacist giving you contraception or whatever it is. And lately, and so more in favor of the idea that you can have whatever religious beliefs you want, but you can't impose them on other people, right? And now the pendulum has really swung to, you have religious rights. Those religious rights include free exercise, which certainly they do. The Constitution says that. But that what free exercise means is that you can exercise your religion even when it does impact other people. And that is the way that religion is going now. And we don't see any, with 6 Supreme Court justices who are really on board with this, it's hard to imagine that not gaining even more momentum.
We need to close, but Lisa,
Okay.
I have 2 very quick questions for you.
Okay. I'm excited to eat the bolognese. Yes, I am.
The issue of precedent.
Yeah.
I'm going to be the devil's advocate for a second, but I don't buy it. This issue of settled law and the precedent. Think about the Lochner era and the Warren Court.
Absolutely.
So you can have 50 years of cases of the court, and then they can be overthrown by the court. Second, can you be, and in a way I have been, pro-choice but anti-Roe?
Yes. So I'll take number 2 first.
Okay.
There are many people who are pro-choice and anti-Roe. And one thing that Alito says over and over again in his opinion is what a lousy opinion Roe was. And you know, I'm gonna agree with him on that. And even Justice Ginsburg was like, yeah, it kind of sucks. It's not very well legally reasoned. Justice Blackmun was counsel for the Mayo Clinic, which is this big like medical center in Minnesota. And he was so excited to have like a medical thing. And it's very medical. If you read it, it talks about viability and it talks about trimesters and all this stuff, but it doesn't really say like, what does any of that have to do with the Constitution? So yes, there are many people who are anti-Roe, but pro-choice. It's really a shame that Roe wasn't better. Yes. Your one before that was
precedent.
I mean,
is it settled law?
Yeah,
the relationship between precedent and the Constitution.
Yeah, it's really tough because the whole point of precedent is that we know what to expect, right? So we know what our rights are, and those rights are consistent across the entire country, which is a very large country with 50 individual states. So if you're in Mississippi, your rights are the same as they are in Oklahoma, as they are in Nevada, as they are in California, right? And that they're the same consistently moving forward, right? And so we have this concept of reliance. So like, I know that the police have to read me my Miranda rights, and that was true yesterday, and that's going to be true tomorrow. And so people are going to be treated the same way. Sometimes it is absolutely true that the law is bad law and that we come to a place in society where we see that. And some people say that overruling precedent is an act of judicial activism. And judicial activism has a very bad connotation to it. But both sides engage in judicial activism all the time. They do it to get to their goals, right? Different people have different ideas of what bad law is, right? And some people think that not only was Roe a bad decision, but the idea of a right to abortion being based in the Constitution is bad law. So we're going to fix that. But at the same time, we certainly are glad that Plessy was fixed, right? So it's very tough. But if we didn't have any precedent at all, every judge could just decide things differently, and it would be different in Mississippi than it is in Ohio, and that would just be chaos, right?
That's what's going to happen if it goes back to the state level.
With abortion, yes, but with lots of other rights that are constitutionally based, no, unless they do away with those two.
Oh, on that
note, Lisa.
I hope you guys, however you think about this issue, that it's been interesting to talk about it for you. I told you I can talk until tomorrow. And I've loved being in Italy. I'm so glad you're all in Italy. God, it's so wonderful here. I love it.
On that note,
thank you
Lisa,
so
thank you very
much.
Any other questions?
Of course. Yeah, it's just, it's Lisa Tucker at Drexel.